been cropped up because of passing on wealth to females who have not participated in the process of wealth creation.
I think the passing of wealth again will be subject to whether the proper instrument of estate planning have been exercised or not in terms of the will or trust, primarily the will. If that is not been exercised, then there is a kind of a structure in the family where there is a possibility of multiple people who are a part of that family. And in that case, it sometimes becomes a challenge, because then the intestate succession rule will apply, and whether that female or that lady member, she is aware of those rules or not, that can become a practical issue. So I think for every wealth manager, it is important that while they are soliciting investments or doing plan for their customer, they should also try and involve the wives who are not a part in the business or not a part of that process, that they should be aware that this is how the things are, and if at all something goes wrong, she can go and approach that wealth planner, and if the wealth planner is there, he obviously can take care of the interest of that female or woman.
Thank you.
Can I just add something, especially for you, since you are all, wealth managers? One thing, there must be nominations, for example, for equity. The Bombay High Court has held, and now it's part of the Companies Act, that the asset will go to the nominee irrespective of what's there in the will. So certain things I think wealth managers must know about, because what happens is in the will, the testator leaves it to X, but the nomination is in favor of Y. But because of the legal position now, which has changed over a period of time, it actually would belong to the nominee. Again, it depends on the type of instrument. If it's equity, may be different. If it's in the insurance, may be different. So you need to know, first of all, under the law, how the asset would devolve based on the nomination, or depending on how it's held. If it's held jointly, for example, you may be able to claim only your half share, and the other half share actually will go to the joint holder. Okay? So that's one thing you must be very careful about. Talk to your client to know how they actually want this asset to devolve upon their death, and make sure that you make the proper nominations as of today, so that there are no conflicts between, how you hold the asset and what is there in the will.
And probably on the insurance side, the Married Women Property Act is also there. So in that case,
you should know about that. Yeah. Thanks, Neeraj bhai. Sonali, as you mentioned just some time back that you have a trust company outside India, but in India you've chosen to go independent with independent trust companies and not set up your own trust company. One is, what's your experience of how important it is to have a trust company? Should the trustees be from family? And why did you choose not to have a trust company in India?
Right. In fact, this is a question which is often been put across to us. See, internationally, as most of you must be aware, that there is inheritance tax. That means if a person passes away, leaving behind a certain amount of estate, almost depending on the country in which this asset is, 30 to 50% of your asset is, taken in the form of tax. And that's why there are a lot of wealthy clients or individuals who would want to have a proper succession or estate planning being done. And trust happens to be one of the most efficient way to plan for these taxes. And hence, obviously, that's one of the key businesses in any private banking businesses, I would say, or in the private banking world, I would say. And that's why we have our trust companies internationally. In India, of course, as we are aware, it is estate tax, or estate duty or inheritance tax. It was abolished in 85, 86. And there is no specific need, or I would say it is not must for every wealthy individual to have a trust. It's completely need-based activity depending on the assets that you have, situation that you have, beneficiaries that you have, and the objectives that you have. You need to set up a trust. So we thought that at this point of time, it's not really important and necessary to have a trust company. The objective that client is trying to achieve, even if the client wants to set up a trust, that objective can be very well achieved by having a board of individual trustees. So family members, friends, professionals can very well form a board of trustees, and the trust it can be managed. Barring certain objectives, say for example, one is looking at asset protection, like insolvency protection in a crude language, if I have to say. Or, similar cases, if one is looking at setting up a trust in case of a marital dispute. Of course, over there, you do need independent trustees, professional trustees or otherwise, but you do need independent and trustees who are not family members, in a way, I would say. But yes, I mean, if a bank is been appointed as a trustee, or in India, if I have to say, if there are certain banks who have their trust companies, there are always limitations in terms of what assets can be accepted by these trust companies under their management, So typically, since we have been talking about real estate, it's a known fact that almost more than 50% of one's estate is there in real estate, right? In that kind of a scenario, maybe bank formed trust companies do not have infrastructure, do not have risk appetite to manage those real estate or immovable asset as a trust corpus or as a trust property. They may be expert and they would have, much more expertise in managing financial assets, but when it comes to real estate or immovable assets, there is certain kind of limitation. But it totally, I wouldn't say one is good over other, whether a trust company set up by a bank is better than the individual or independent trust company. It is completely based on client's requirement. If client is setting up a trust with lot of financial assets, yeah, maybe going to a bank trust company can be an option that can be considered. Only important thing is, as a wealth manager, if you are recommending a trust company, whether it is floated by a bank or an independent trusteeship company, you got to see whether that trustee company will manage the asset which this trust is going to hold. That's the key thing as far as this structure is concerned.
Thanks. With that, we would like to wrap up. Thanks to all the panelists. And in case there are any questions, please feel free.
Hi, I'm Sohesh. Can you throw some light on the liabilities of the trustees in case of a trust? In case where all the trustees uniformly decide to invest in some of the investment avenues, and something goes wrong in that. So what is the liabilities of trustees in that case?
Okay, I'll answer that because I'm the lawyer actually. See, the Trust Act provides that in the case of mismanagement, I'll use the word, it's actually gross negligence or willful default or fraud, then the trustees can be held liable. If they have, carried out some act in exercise of the powers and discretions under the trust deed, where there is no willful default or gross negligence, then usually they would not be liable. One thing few people are aware of actually though, because under Indian law and of course the world over, the asset is held legally by the trustee. So technically a third party can sue a trustee, okay, for loss suffered to a third party by reason of any acts or omissions of the trust or in entering into contracts or dealings. However, the trustee in such a case is entitled to be indemnified from out of the trust properties. So even if a third party sues you, you can, take the money from out of the trust funds because you are acting for and on behalf of the trust and acting in good faith. If there is an absence of good faith in your acts, then yes, you could become personally liable.
Yeah, a little add to that. Basically, there are two types of liabilities a trustee faces. As Marilu was saying, one is from third parties, the other is from the beneficiaries. So third party liability typically arises where contract is not fulfilled and such like things, which is normal to any trustee, and he has a right to claim those from, if there's no willful, being the fashionable word today, default, then yes, there is a case where the trustee can claim assets, indemnity from the trust funds. With respect to beneficiaries, the beneficiaries can sue the trustees, and it may be held against them for willful misconduct, malfeasance, fraud, as was said. But more importantly, a prudence to manage the affairs of the trust as one would manage somebody else's affairs, not your own affairs, but somebody else's affairs. So it's a very high fiduciary capacity which is entrusted to the trustees. Thanks.
Thank you.
Any more question? Okay.
Would like to know how effectively the MWPA is genuinely being practically implied. Can the MWPA genuinely play an important role in protecting the woman's right, what we say? MWPA.
MWP,
How effective it is in practical purpose?
How effective is MWP in practical?
The Married Women's Property Act.
I have not.
Okay, so I can take that. So MWPA, it's first of all Married Women Protection Act and not Property Act. And it is basically, it depends in terms of, it is very much effective, but one needs to understand that it is related to insurance, and it becomes effective only on the death of the policy holder, right? So that's the basic point that most of the wealth manager miss on. It is not asset protection vehicle which can be used during the lifetime of an investor. It becomes effective only when the person is no more. So depending on the nominations which have been done and the rights which have been assigned either to wife, under MWPA rights can even be given to child. Okay, it's not just restricted to your wife. Depending on how you have defined it, when you fill up the form, there is provision to do that. Depending on that, it is 100% effective. I wouldn't like to take the name over here, but the scam which happened, the biggest scam, the property to some extent was saved because there was a huge policy, insurance policy that was taken under MWPA.
Yeah, just to add to that, MWPA, as she said, applies only to insurance, not to other properties which the woman may hold.
Can many trusts be formed for achieving a goal? Like, let's say in financial planning, there is a goal, let's say for a retirement, not for retirement, for a children's education or a marriage. Can two trusts be formed?
Yes, of course.
Mutual fund is the biggest trust for that.
Of
Mutual
course.
fund is a trust.
Yes, mutual funds are formed as trusts. Of course, you can form n number of trusts for any number of requirements.
For a single person?
For a single person, so marriage could be separate, education could be separate, income could be separate.
Yeah, just one thing also, if in a trust structure, if all the beneficiaries are majors, they can ask for a dissolution of the trust and the properties to be, handed over to them. So if you want an effective trust structure for a long period of time, you must add unborn children also, because once they're majors, or if all the beneficiaries are majors and there are no minor beneficiaries, then the majors can ask for the trust to be dissolved.
In fact, I would add to this, it's a good question that you have asked, and this is something that I would like to tell all wealth managers, that please don't try to achieve different objectives through one trust. You need to have different structures created, and this needs to be informed and explained to the client. Many a times, it's always, one looks at trust as one structure and tries to achieve too many objectives out of it. So taking care of a special child could be one objective, taking care of a married daughter could be another objective, protecting wealth for yourself can be one objective, incapacitation planning is another objective, purely investment, preservation and protection is another objective. These are different objectives for which one needs to consider different structures. It cannot be like, although it's one vehicle, one type of vehicle, but need not mean it's only one structure. So in fact, it is important to create multiple structures when you have different objectives.
Yeah. So with that, I think we'll wrap up.
Yeah, thank you so much to all our panelists for sharing us the insights, and I'm sure this will help our audience. So please be seated. I would like my audience to present mementos to you. Can I please have the people who have asked the question, please? Can I have please 3 people who have asked the question and my panelists who have answered? Yeah. There was one more in front, I guess. Please come. Yeah, you can give to Tutu. Thank you so much. Thank you so much. Mr. Rupesh, you can give to one more. Yeah. Thank you, sir. One more. Thank you all. Thank you so much.